Missouri requirement, conspicuous disclaimer. Now, I know you're looking at the slide and saying, ouch. And that small text at the bottom, note the above text is likely too small and indiscernible to qualify as conspicuous. I can't even read it. This is kind of my whole point. This is how people design websites. They put all the sales text and the no pay unless you win, and then they put all the disclaimers in size 5 font at the bottom of the page, or they have a little link that says disclaimer that pops up to another page that has all the jibber jabber and disclaimers and legalese. That would probably not meet the Missouri requirement of a conspicuous disclaimer. Nearly all sites are going to require some disclaimer. The exception to the conspicuous disclaimer rule, if your site only has your name and firm name, contact info for your staffed offices, the ones with lawyers in them all the time, a list of your practice areas, and a list of your bar admissions. That's it. If you only have that, basically a business card on a website, you're fine. If you include more than those very thin factors, then you have to include this form disclaimer. The choice of a lawyer is an important decision and should not be based solely upon advertisements. I've seen this rule pop up in other states too. Again, they all base it off model rules and they all steal from each other. Check your state's rules. It's not that hard to put this disclaimer in size 12 font at the bottom of your page where people can read it, where it's big enough to be seen in a nice visible font. Other conspicuous disclaimers you probably need to include or often need to. If you include verdicts, again, results not guaranteed. If you have stock photos, all website designers use stock photos. You have to have, and I've never seen this on a website, but you're supposed to put it, dramatization of lawyer, client, victim, scene, or event. Put that under the photo. If you give out payment for endorsements or testimonials, you have to have a disclaimer. I know a lawyer who, when I took on his firm for marketing services a few years back, he already had like 10 reviews on Google and like 20 on Avon. I was like, well done, man. How'd you get that done? Because this is the first thing I talk about with every lawyer is get the reviews, because that's the quickest way to get your phones ringing. Oh, well, I gave a $5 Starbucks card to anybody who's willing to leave a review after I gave a presentation on the law. Well, he just paid those people for endorsements and testimonials. He needs to add a disclaimer. Plus, if those endorsements and testimonials pretend to be clients when all they did was sit through a seminar, now you're contributing to false and misleading advertising. His didn't, fortunately, but he did need to add a disclaimer that they were paid endorsements or testimonials. Another one that I see a lot, part-time or by appointment office addresses. You will need a disclaimer on that. We're going to come back to that in just a second. And again, if you are advertising for practice areas that you don't practice, that you refer out to other people, you have to have a disclaimer on that one.